Welcome to the Polity Prelims program. We will be discussing citizenship today. My name is Atish Mathur. This is my Telegram channel, and you can access this channel by simply clicking on the link mentioned here. Let me right at the very beginning contextualize citizenship from the point of view of the prelims exam. It is a matter of fact that over the last 10 years, not a single question from citizenship has ever been asked. But the Citizenship Amendment Act of 2019 might just change things. This was such an important event in the history of this country last year that this could possibly put citizenship back to the forefront and relevant for the exam. And we're going to be studying just what is needed as far as the prelims is concerned. The first that we will discuss is citizenship and the law. Let's understand this. The primary and the first place where provisions regarding citizenship are mentioned are in the very Constitution, under Articles 5 to 11. These articles clearly define the provisions with respect to citizenship. In addition to this, entry 17 in the Union list also refers to citizenship. This makes it very clear that the centre or the parliament has the powers to make laws on citizenship. In fact, one of the articles clearly mentions that the parliament can regulate citizenship further by enacting laws. This is a classic example of the unitary form of federalism that India so vehemently practices. In fact, as a national nodal agency governing broad regulations of citizenship, we also have the Citizenship Wing, which is a sub-department under the Foreigners Division of the Ministry of Home Affairs, which is your nodal agency for citizenship. These are provisions with respect to the Constitution. Now, as you would know, Articles 5 to 11 may not be enough to cover all the technical details with respect to citizenship, and for the same reason, we enacted the Citizenship Act of 1955 as a supporting legislation to get into the details of how citizenship works. This act is further supported by the citizenship rules, which have also been amended numerously, which give you the procedural details. It is important to note that both the act and the rules have been amended several times. In fact, the recent amendment of the Citizenship Act happened in the year 2019, and the citizenship rules, which are an example of delegated legislation, have also spoken about something called the Citizenship, Registration of Citizens, and the Issue of National Identity Card Rules 2003. Now, this may not sound very familiar, but this is the foundation which recognizes something called NRC, which was the focal point of the national debate last year. The National Register for Citizens is essentially a list of legal citizens of country, which is based on something called NPR, which is the list of residents living in India. And that's it. And the origin for two of the most highly contested issues in Indian polity last year owes to a set of rules, a part of the Citizenship Act of 1955. It is also very important to mention a very important principle called single citizenship. This means an Indian citizen can only be an Indian citizen. No Indian can hold the citizenship of any other country apart from India. This is a principle that we strongly stand by. Now let's look into how to become an Indian citizen. The provisions on how to become an Indian citizen are mentioned in two places. The first the Constitution of India through Articles 5 to 8, and second, the Citizenship Act of 1955. Let's address the Constitution. The Constitution largely talks about a historic way of becoming an Indian citizen, and it refers to two primary setups. It looks at as on 26th January 1950, that's the date of commencement of the Constitution, where the Constitution was brought in force. Or it also talks about people before 26th January 1950. This is largely because India was deeply affected by migration and the partition of India into East and West Pakistan. And East Pakistan today is called Bangladesh. So the Constitution largely talks about how to become an Indian citizen as of 26 January 1950 or before 26 January 1950. Let me also make this very clear. For the purposes of the prelims exam, you do not need to know the technical details mentioned in Articles 5 to 8. You will not be asked the same in the exam. As long as you understand what period is it referring to, that's more than enough. And from the commencement date, to give further details and guidelines, we came up with the Citizenship Act of 1955. And the Citizenship Act of 1955 dominantly mentions 5 ways in which a person can become an Indian citizen: birth, descent, registration, naturalization, and incorporation of territory. It is often questioned as to whether citizenship is a right or not. The answer is both. The answer is depends on how you're becoming an Indian citizen. This is very similar to foreign direct investment, which happens in 2 ways: the automatic route and the approval route. And that's essentially what we talk about. Birth and descent are entitlements, are assurances of citizenship, which means if you are an Indian citizen by birth or descent, you're entitled to Indian citizenship. This is the automatic route. But as far as registration and naturalization is concerned, these are application based. These depend on the discretion of the government, the approval of the government. And lastly, incorporation of territory. Now, this happens when India acquires the territory of another country. For example, in our video on union and territory, we had discussed something called the land boundary agreement, where there was an exchange of multiple kinds of land, including enclaves. And there, through a government order, we also recognized and gave citizenship to people who were now a part of Indian territory. The Citizenship Act also defines the overseas citizens of India, and it also defines who is an illegal migrant. This will play a very important role in our further discussion on the Citizenship Amendment Act of 2019. Now, let's look at each of these provisions in a little bit of detail. The Citizenship Act of 1955. Let me also make this very clear right at the very outset. You don't need to know what were the laws previously. All you need to know is how does one become an Indian citizen as of today. We'll look at birth and descent in this slide. So if you are born in India and either both of your parents are Indian citizens, or at least one is an Indian citizen and the other is not an illegal migrant, and you know we already have a definition of it, then by that logic, you are an Indian citizen by birth. Descent. Descent means you're born anywhere else in the world except India. Okay? Except India. In that case, at least one of your parents is an Indian citizen at the time of your birth, and this has to be registered with the Indian consulate of the country that you are born in within 1 year of your birth. Now, under special circumstances, this may be waived, but broadly, these are the basic conditions as to how one becomes an Indian citizen by birth or by descent. Simple enough. Please do not get into the technical details of it all. Please do not get into the time frames of it all. For example, between 26 January 1950 till June 1987, from July 1987 till 2003, and then 2003 onwards. These are all amendments that have happened. Please don't bother about it. You will not be asked the same as far as the prelims is concerned. Then you look at registration and naturalization. This, as I've said before, entirely depends on the government. You may fulfill all of these conditions, but you still may not be guaranteed a citizenship of the country. A few examples of registration is it refers to how persons of Indian origin can become an Indian citizen. A person of Indian origin is anyone who's currently not a citizen of India, but their ancestors were a citizen of India or could have been at that particular point of time. Now, a simple way to look at it is you would have lived in India for about 7 years. You would have traveled in and traveled out of India. That's okay. As long as you can show about 7 years of coming in and coming out. But 12 months before you file for citizenship, officially as an application, you should have continuously stayed in India. Just one of the reasons, just one of the ways. The second is married to an Indian and residing for 7 years, inclusive of the 12 months of continuous stay in India prior to the application. Third, the overseas citizens of India, who are also not citizens of India but have been given a card because of certain conditions mentioned in the Citizenship Act, and you hold the card for about 5 years, and you are residing in India continuously for 12 months prior to your registration. Again, none of this has to be technically remembered for the exam, but just one of the ways we do it. And then comes naturalization, the most open-ended of it all, with pure discretion of the government. So, you could have served the Indian central government, or for example, you would have resided in India for 11 years. These were the original terms of naturalization provisions, and these are now bound to change. Welcome the Citizenship Amendment Act of 2019, which primarily changes three things. One, the definition of illegal migrants. Two, the processes of naturalization provisions and how we are changing certain legalities and illegalities out of it. And three, the penalties that we accord to the overseas citizens of India. Because when we change the definition of illegal migrants, it directly impacts naturalization provisions, and therefore it's important to look at it in this particular order. Let's start. The first change that happens because of the Citizenship Amendment Act of 2019. It changes the very definition of illegal migrants. Now, you would know that there was an amendment which was notified eventually in 2005 through rules as well. So, this has a conjunction to all of those in addition to the Parent Act of 1955. So, what is an illegal migrant? An illegal migrant is anyone, very simply, who is traveling without a passport or the necessary documents such as a visa, or has extended their stay beyond what was permitted. This applied to anyone and everyone, and this anyone is now set to change. There is going to be a certain number of exceptions to this anyone, and these exceptions are very simple. Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians from Afghanistan, Bangladesh, and Pakistan. So basically, everyone except Muslims from these countries who entered India on before 31st December 2014 will not be treated as illegal migrants. 2014 is the year a new government came into power. So, because of this, anyone who entered India on or before 2014, 31st December, and fulfilled this criteria will not be treated as an illegal migrant. Simple enough. And these illegal migrants, the provisions of these illegal migrants will not apply in two cases. One, the tribal areas of Assam, Meghalaya, Mizoram, and Tripura, which are included in the sixth schedule to the Constitution, and secondly, inner line areas or inner line permit areas, as they're more colloquially called, which are notified under an archaic British colonial law called the Bengal Eastern Frontier Regulation of 1873. Today, the states of Arunachal Pradesh, Mizoram, and Nagaland use the inner line permit systems. And that's essentially what this is. The Act will apply everywhere in the country except these specific areas. And this is how we change the definition of illegal migrants. Now, we then change naturalization provisions of the Citizenship Act and Citizenship Act, the rules as well as the 1955 Parent Act. Now, originally, as you would remember, 11 years was the case. You had to reside in India for 11 years. This 11 years period has been reduced to 5 years for everybody who was exempted under the illegal migrants definition. So, Hindus, Sikhs, Buddhists, Jains, Parsis, Christians from Afghanistan, Bangladesh, and Pakistan. That's essentially what it is. So, if you think about it, the new government comes in the year 2014, and in 2019, the new amendment happens. That's a difference of 5 years, which is essentially the same difference which has been reduced to. So, which basically means within the 5 years of the new government and the amendment coming into shape, non-Muslims from Afghanistan, Bangladesh, and Pakistan can now apply for naturalization ways of acquiring Indian citizenship. If their citizenship application is accepted, they will become Indian citizens from the date of entry into India, not from the date of their application, which is a massive advantage to these people. In addition to this, all citizenship or migration related cases against them shall remain closed with immediate effect as soon as they become naturalized citizens of India. All right? And therefore, you welcome a new set of people into the country through a process called naturalization. And thirdly, it adds certain criteria to the cancellation of registration of overseas citizens of India. The provisions of this are also mentioned in a tad amount of detail in the Parent Act of 1955, which also don't have to be done for the purposes of the prelims exam. All that the new amendment says is that the government can add certain cancellation provisions when they feel like, and second, if the government decides to cancel the overseas citizenship of India card of anyone, the person will be given an opportunity to be heard before this is actually executed, which essentially is nothing but the application of the principles of natural justice. Let me also make this very clear. You will not be asked political questions around CAA, NRC, NPR, or any such. You will not be asked your opinion or your judgment. Do you think whether it's right or wrong as far as the prelims is concerned? All you need to know are the hardcore facts. Now, we've understood about how to acquire Indian citizenship. Let's look at how to lose Indian citizenship. Losing Indian citizenship largely happens in three ways: renunciation, termination, and deprivation. Renunciation is when a person voluntarily gives up Indian citizenship. Or renunciation happens where there's a conflict between India and another country, and that could be some repercussions. And that is how renunciation works. Next is termination. If a person, for whatever reasons, acquires the citizenship of another country, which you know is a strict violation of our single citizenship principle, the Indian citizenship shall stand terminated if the person doesn't lose the other recently acquired citizenship. And thirdly, this is where the drama or the theatre begins: deprivation. Deprivation contains a list of clauses which include somebody who has filled their citizenship application via fraud, which means they have incorrectly placed certain information. It could also be disloyalty to the constitution, if the need might be, which again is a very, very vague criteria. The point to note here is that the government would have extraordinary power not only in granting citizenship through naturalization or registration, but also taking citizenship away of anyone just in case because of the grounds that are mentioned. So, this would largely always apply to registration as well as naturalization. Otherwise, it's very difficult to terminate an Indian citizenship on the basis of birth or descent. It's next to impossible. Now, a simple question arises: how does one apply for Indian citizenship? Believe it or not, there are actually two modes of it: online and offline. Online, there is actually a website, indiancitizenshiponline.nic.in. Offline, if you live in India, you can apply to the nearest office of the district collector in the area that you're in. If you live anywhere else in the world, then you apply to the Consular General of India, who's the highest ranking diplomat representing India in that country, a very senior officer of the Indian Foreign Services, and is posted in that particular country. In fact, this website gives all possible technical details with respect to the application of Indian citizenship. Right? Let's take a minute and look at some of the terms that go beyond citizenship. For example, a refugee. A refugee is someone who's forced to flee his or her country because of persecution, war, or violence. Now, this could happen for any of the reasons and is one of the world's most pressing problems. In fact, you should know, two-thirds of all the refugees in the world come from five countries: Syria, Afghanistan, South Sudan, Myanmar, and Somalia. That's about 67% of refugees of the world. Then there is something called an internally displaced person, someone who has been forced to flee their home but never crossed an international border. At the moment, you must understand, countries with some of the largest internally displaced populations are Syria, the Democratic Republic of Congo, Somalia, and Colombia. There are 41.3 million people in the world who are currently internally displaced. Third, a stateless person. A stateless person is someone who's not a citizen of any country. Interesting enough, because citizenship is the legal bond between the government and an individual and allows for certain political, economic, social, and other rights of an individual, as well as the responsibilities of both the government and the citizen. A person can become stateless for a multiple number of reasons. They can include sovereign, legal, technical, even administrative decisions or oversights. It's interesting to note because the Universal Declaration of Human Rights says that everyone has a right to nationality. And next, there's something called an asylum seeker. The right to be recognized as a refugee and receive legal protection and material assistance. An asylum seeker must demonstrate his or her fear of persecution in his or her home country, which is well founded. And that's what an asylum seeker is. And this asylum seeker then seeks the patronage of the country. And from the international law perspective, we have something called the 1951 Geneva Convention, which clearly spells out who a refugee is and the kind of legal protection, other assistance, and social rights he or she should receive from the countries who have signed the document, which India has rights, but India does not have its own domestic refugee law. And this should cover all possible elements with respect to citizenship and beyond. I hope this video was of some help to you. If it was, and if you do like this video, please like the video, share it, and do subscribe. It is severely motivating to see such positive feedback. Thank you so much. Good luck and happy studying.